some hearsay or whatever, but it was the evidence before me.
She did another clearer picture. Now my age is showing.
So that's what the president, it shows that he understood as the deputy.
10,000 rand, the that in is whether the duty to declare triggered.
That's as simple as that. Remember, again, still repeating to members, chairperson, members of the public, going forward, know that the public protector, we check what happened, what should have happened, where's the gap there, what is the law saying, and how to remedy that purely. So here, he acknowledged that 500,000 and the bank statements, the emails, where he even personally said, move 75, and I didn't take the precedent. So for me, the decision was taken, and when the drafter of the evidence and the analysis of the evidence, which is done by the chief investigator, where is the evidence? And that's what we did. So we were following this 500.
If there's one or two issues that
no, it is, Chair, but
yeah,
please, Chair.
I'm eager that we.
Yes, no, we definitely are, Chair. But
I think
I'm also sensitive to that.
Well covered. Thank you.
Yes,
but
thanks.
Proceed.
Thank you, Chairperson. Yes, no, okay. I was actually going to start this question by saying, at the risk of the chairperson is stopping me, but that risk is now already occurred. But I do want to emphasize this. As I say, I mean, this is a highly controversial and political matter and so on, and it might get politicized, but we must not be waylaid by that. So the point I'm simply making is that assume the chairperson said you stumbled into all these other millions. Assume you had not stumbled into anything for a minute. Assume you didn't stumble into the bank statements, the emails and all the things. Okay, maybe not the emails, because the emails served at different purposes, but let's say the bank statements and the other big amounts and what have you. Purely on the basis of the 500,000 amount, which the president himself brought to the attention of Parliament as having been received by the CR17 campaign, and which is obviously more than 350 rand. Just on the basis of that, forget the big amounts. Was your conclusion that there had been a breach of the Members' Ethics Act sustained?
Definitely it was, because that was the focus, actually, 500,000. And even if it was more than 1,000 rands or 10,000 rands, and if he didn't acknowledge that and confirm that, and the complaint is lodged, we wouldn't have known about that. We wouldn't have investigated. And the complaint lodged by the DA, not to say me following up or saying, President, you said this, now
so
you're. Or the issue of own initiative. That's not the case. I mean, the investigation was done in terms of the Executive Members Ethics Act. Member of Parliament complained. The investigation was conducted. And I think that's why, Chairperson, it's very critical that I place this on record, still repeat. It means then that my version currently, because that's what I'm presenting, considering the fact that certain information is also sealed, And I think it was going to be, and the president acknowledged at the Zondo Commission that it's around 300 million. But then it was also going to help the committee to directly also engage the president on the matter, but you've taken a decision that you are not going to call him as a witness. So I think then the information which I'm presenting, assisting the committee to decide on this charge, then it means my version will be the only version which is before you, and the evidence I'm presenting currently, just to make sure that I show to the committee that this was done honestly without any ulterior motives, and I was just doing my work the best I know how, according to the constitution, the law, and these are the relevant prescripts I followed: the Executive Members Ethics Act, and the president was the member of parliament as a deputy by then when the money was paid, and was obligated as well to declare in terms of that. And when we check the records in parliament, the declaration of this amount was not made. Thanks.
Okay, thank you. you've helped me out. Then I want to ask you about the implications of not calling the president.
Mm.
So the last point then is to round this all up. I'm now spilling out. This last question spills us out of the 500,000. You've answered about that. And we know that we don't have, and you are not at liberty to share the sealed document.
Yes.
You've referred to all this movement of money, bank statements, emails, and what have you. Yeah. But what we do have access to is what is at paragraph 261 of your statement, and that just gives us a glimpse or a window. Page 261. Paragraph 261, Tsepo, and I'll just ask you to comment on the implications of that.
And hide the account, Tsepo.
Sorry, pardon?
Tsepo, hide the account.
Or the account number,
Mm.
Tsepo? Yeah, just go further up until that line of the account number.
Yeah.
After
so
account
that's-
number, where it says account number, go more. Yeah. So I'm saying just to close it off then. So you stumble then over all sorts of information, and one of them says, "Hi, Donald. Thank you for assisting with the internet banking and the other day. Could you kindly transfer an amount of 20 million from the money market investment that was left after we shifted? So the person is included himself. After we shifted 75 million from the money market select to reattend the trust standard bank account number blank, 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 then go down and hide the thing from the top that now. In other words, exclude just the following line. Yeah. And it's we can read the part that is not shown, but that is not controversial. It says, I shall call you to confirm all this, signed Cyril.
Yes. And
Okay. Now
that shows that he knew he was involved in the running. And as I said, that even these monies which were transferred to the Cyril Ramaphosa Foundation, but this is clearly showing that he was involved, but as well that the dinners, he confirmed he went and he addressed those people who participated.
Yeah, so therefore to say you disbelieved him or you didn't trust his bona fides or whatever it is, without any reason, which is really what was the conclusion of the court. In the light of this, is that sustainable?
It's not sustainable.
Okay, thank you, Chairperson. That's what I wanted to.
Thank you.
Super. Thank you so much. Okay. Right. Okay. Now, but before, okay. Just want the Chair, if you allow me, I'm just going to deal again with this a very small section on the vision here. You'll see the connection. I'm just building up to our next section. If you go to paragraph 154 of your statement,
Okay.
that's 561, typed 65, Tsepo.
154.
154. Right. Okay. So you had what you call Vision 2023.
Correct.
And now it's 2023.
Yes.
Okay. So if you can add, and I just want the highlights, please, and you'll see the connection when we get to the next big section. So you come into the office, October 2016, you see what you see, you find what you find, and then at some stage you then build your vision for the non-renewable 7-year term ahead. Correct?
That's correct.
Yeah. And you then had, and I'm doing this also because of something that we raise in the second statement, but we'll do. With it when we get there, which is that, and I'd like members to keep this at the back of their minds, that, you know, all these cases that we are busy with here are the, what you call it, high profile cases, you know, CR17, Rogue Unit, CX, Friede, and so on. And those are 4 or 5 big cases. And we lose sight of the 50,000 cases of so-called Gogo Dlamini, Mr. Nyatela, Mr. Siabi type of customer. Yeah. So can you just broadly just take us through the headlines of the vision? And they are set out in paragraph 157. The first one is access. The next one is vernacular. The other one is footprint. Other one is agreements. Other one is safe haven. Safe haven. Other one is rights. Then resolution. And the last one, I think, is self-protection. Yeah.
Thank you.
Can you And once all that is done, what then happens at your level? At what point does the matter come back to you? And by that, I mean, when are you going to meet with this matter again? Will you meet it at, I forgot what your meetings are called, at dashboard or at, what is the other one called?
Task register
Yeah,
meeting.
task register and what have you. Once all those preliminaries are done, when is your next, I'm talking about at your level, your next interaction with this, with a matter like this?
You know, as the public protector, that's why sometimes when you just explain to people, or when we were engaging with the remunerations committee, when they were asking, sorry to digress, Chairperson, they're asking, but what at what level, or you know, as a public protector, what is it expected of you? Because you are an executive authority. And we were giving an example whether the minister is involved in Rule 53, in preparing Rule 53. But again, as a public protector, you find yourself, because the Constitution says public protector, investigate. And the Act says I've delegated those powers. But then when it comes to the issue of EMIA, for instance, in this one, then there's an issue where I would then insist that the task register, which is the weekly process, which I had to say, COO, CEO, well, COO is a chief operating officer for those who don't know, CEO, chief executive officer.
And ACE is acting chief executive, not Ace Mahashu.
Yes, the CE actually, the late Mr. Nyembe, my chief of staff, used to say, instead of saying CEO, would say CE, chief executive, like in SOEs.
Yeah.
So he came with that. Now, when the person who was acting, then we would say ACE. Now we adopted his way of doing things. Yeah. So that's where I engage with matters. That's where I will ask, okay, we've received this complaint because I've signed the letter. I've seen that we have this matter. And it's what we call, which I adopted from my predecessor, special attention matters, SAM. So I didn't stop that. I would say I want to know on all these key issues, because those are the matters, they'll be in the media. I receive media inquiries. I'm also being criticized or attacked that we are delaying on these, or political parties threatening to take us to court. So I need to be aware. So that this matter was one of those. So it was in the agenda of task register.
Right.
Yes.
Good. And right. So then we'll come back to the process issues, because the chair will now ask me to come back to the rogue unit matter.
Yes.
Yes. I can read it now.
Maybe we're ready for lunch now.
And we're ready.
So when we come back to lunch,
then
we'll
we'll
back to the unit issues.
Thank you, PP. I think that gives us a good platform.
We'll take a lunch break, back at 2.
Recording stopped.
Welcome back. We resume the hearing. Back to the unit issues. Going to ask Advocate Mbofu to get into that. I think
Thank you, Chair.
you would have landscaped it already. Thank
Yeah.
you.
Thank you, Chairperson. Right. So for now, let's just go past what is the exposition of the issues and the approach to the investigation and so on. That you dealt with when you were doing your landscaping last week, 2 weeks ago. What happened, what should have happened, and so on. So now
Yes.
we have at 4.3, which is page 30, of the report. 30, 11, small 114 at the top. That section then says, on analysis of the complaint, the following were the issues considered and investigated. And basically, we don't have to go through that. You then list the issues again. And I take it, I think, from Ms. Mkhwebane that's now after the interaction with the complainant, where you say you lock the issues to avoid issue creep.
That's correct.
Right. And 4.4, can it tell us, there's a list of so many things there, which the key sources of information, and I think we pointed out to one of the witnesses, the word key sources. So it's clearly not intended to be all the documents, but what do you normally include there?
Where we include the documents we have relied on, the correspondence with the various institutions, their responses, their recordings, if we have any recordings which they provide. We also then deal with the section 7(9) notices which were issued to the implicated parties. So the sources of information is what was before us when we were conducting the investigation and what we relied on when we conduct the investigation.
Right.
For instance, if you deal with recruitment, you have to have their recruitment policies. If we deal with procurement, we'll have to have their procurement policies, the reports which were there, or any documentation which we received from all the institutions which we have approached.
Right. And this is a question I should ask you later on when we deal with the so-called IGI report. But I think for the sake of, because everyone knows the issue by now, we can raise it now just to flag it. You'll remember that one of the accusations or issues that are raised as a basis for criticism is this suggestion that you at worst is that it says you articulated explicitly, Nochal, that you had not seen the IGI report. I think by now everyone knows that it doesn't, there's nowhere in the report where it says that. But I think a sub-theme of that is that, okay, well, maybe you did not articulate it explicitly, but somehow you concealed that fact. Which is not the accusation in the judgment, but it's now a new variation. But let's try and meet even that variation. If just go to 4.4.1.29. No, let's start firstly with 4.4.1.12, page 32.
I think it starts at 4.4.1.6, page
0.6.
31. Yeah.
Okay, that's the letter. Yes. Okay, yes, that's a cluster of letters. I was just going to the last one. You want us to go to the first one?
0.6, the letter to the OIGI.
Yes. Yes, that letter. That's, and then the 0.7 is another letter
Their
to
response, yes,
and 0.8
is the subpoena to the minister,
0.9.
is the letter from IGI.
Okay.
Again.
Yes. 0.10
is the letter from the acting DG of South African Security Agency.
0.11
is the letter to the Minister of SSA.
and then 0.12.
That's the letter, the response of the minister.
Yes.
So
Now
all these letters are dealing with the issue of
the report.
the report.
Yes. Okay. Now, would anybody reading those letters, given the content of those letters, some of which we have gone through, I think, with Mr. Matabuche, can anyone who has read those documents ever think that you were concealing in this report that you had a report anonymously dropped at your offices, given what is actually written in those letters?
Definitely not. A reasonable person would not think like that.
Just keep the mic closer.
Yes.
A reasonable person will never think like that. And a person who will assess and adjudicate this matter with an open mind will never think like that.
Right. And if anyone really, after reading those letters or referring to them or even understanding what they are, whether that person is a judge or a member of parliament, and they have letters in which some of the letters say, I have a report, or you have a report, please give it to us. And there's a whole fight about it. Would it ever be justifiable to say, actually, you were concealing the fact that you had such a report?
I don't know where that, well, I don't understand why they came to that conclusion, but we're still going to deal with the judgment.
Yes.
Because at the end of the day, being the public protector, receiving all kinds of information, being the public protector, who is a safe haven for whistleblowers, who receive documents from all and sundry, people who are following up on such investigations, who are interested, sending information. Therefore, my responsibility as the public protector was to get the document from the state institution, which is the custodian of this report.
Yes.
So all these letters, they are explaining, they are very clear. The recordings are even indicate that I have this report anonymously dropped. Can you avail the report? Can you confirm you have the report? You know about the report, which was confirmed in the responses.
Yes. And specifically, can I take you then to 4.4.1.29? Just to emphasize that point. 4.4.1.29, that's on page 33. 21, yeah. there you disclose that among the key sources of information is recordings relating, no, I'm sorry, further documents blurred and or not listed due to their nature.
Definitely.
Yeah. What among those were you referring to?
I was referring to the very same IGI report. I was referring to the equipments, which to me, I felt for being security conscious
Mm.
and not wanting to expose the country to unnecessary. I mean, these are, well, the allegations or the discussions with IGI, where even the minister was saying, you know, you'll be exposing the individuals or our sources and even our security or our intelligence trades and all those. And it's very clear because the Constitution demands of me when I issue any report, unless there is something which I need to ensure that it's not published, I can then not publish that report because it demands of me to issue a report, but then unless then there are circumstances which I need to take into consideration for the protection of the security of the country or for the protection of the information.
Yes. Yes, sorry, I've just misplaced my act. Yeah, Chair, when the time comes, I'll refer to actually there's a reference to this in the Public Protectors Act, and I'll refer the committee to the specific section. Yeah. All right.
Section 8, yeah, and then the Constitution is section 182. 1, yes.
Yes.
The publication of reports.
Yeah. All right. Okay. Yeah, 1821 is the broad one, but
Yeah.
in the Public Protector Act, you're saying section 8, then there's specific
section
reference
8, yes.
to security concerns. I just wanted the actual wording, but it's fine. We'll get to it when at appropriate time. Then under 4.4.2.1, again, you disclose something there. Can you read it out?
4.2.
4.4.2.1.
The correspondence from SARS.
4.4.2.1.
4.2.1. The recordings relating to the operations of the intelligence unit.
Yes, again, for someone who was concealing or hiding this issue of the possession of the leaked report, what were you talking about there?
There it refers to the information which we received or the evidence which we've received about the said members of the unit who were interviewed by the former commissioner of SARS and who confirmed the operations of the unit and what it was expected to do.
Right. Okay, now, all right. Okay, then let's then go to the issues. Paragraph, page 35. Oh, sorry, before to that.
Before 35, I think the legislation.
Yes, no, even before the legislation, just a question that might go into the chairperson's issue. You go to 4.4.4. There you list then the people who did receive Section 7.9. You've explained why Mr. Van Lochenberg didn't get it. But so we've got Mr. Pillay that we know is clearly an implicated party, Mr. Mahashula, Mr. Kodan, but at 4.4.4 you have Minister of Finance, Mr. Trevor Manuel, that you served with the 7.9, and to which the chairperson might say, why did you do that if you say Section 7.9 are only for implicated parties? To what extent was he implicated?
Maybe starting from 4.3, those are the people who we've served with the OD, which is a notice, and then they responded. Mr. Manuel, it was because he approved the submission of the memo, which was written by Mr. Kodan when he was the accounting officer at SARS by then. So then he requested approval from the Minister of Finance. So we were giving Mr. Manuel an opportunity to, because he's implicated, he approved the establishment of this unit. Yes.
Okay, good. So because at that stage, Mr. Kodan, at least as far as that particular allegation is concerned, he was not a minister, he was a commissioner for SARS.
Correct.
All right. Okay. Then the legislation, again, I think will tell us a story before we read the report as to what we lawyers call the regulatory framework that governed, against which rather the factual findings would be measured. And if I may, it's the Constitution, the Public Protector Act, South African Revenue Service Act, PFMA, National Treasury Regulations, National Strategic Intelligence Act, Interception of Communications and Provisions of Communication-Related Information Act. That's the mouthful. That's the one that says you can only intercept people's communication if you have a judge, or rather a court order, yes.
Correct.
And then the SARS recruitment and selection policy. Okay. Collectively then, can you explain why, firstly, it's necessary to put those, and what role does that section play?
This role, or the section, when you are somebody who's adjudicating our matter before court, you'll see that this is the legislative framework which we checked against the investigation process, what happened, what should have happened, so are the facts, and then whether there's any gaps in whatever should have happened. And remember, the complaint also was saying they violated Section 209 of the Constitution, which addresses the issue of the intelligence, and if it's done by another institution, the president should give a go-ahead on that particular issue. Also, we were showing that the procurement, the violations of the Public Finance Management Act, because we are dealing with accounting officers here, the issue of the SARS Act, we had to check it because we need to understand their operations, the powers of the accounting officer, the role of the minister as well, as far as that is concerned. The National Strategic Intelligence Act, what does it say? So this is what the public protector is all about, like the Auditor General, because we just check whether any improper conduct, is it compliant with the provisions of the laws governing that particular institution. So this was purely that.
Good. All right. And
then the case law also, we referred to this because we relied on them, especially when the responses of the implicated parties or when we investigate, then we need to highlight these cases so that we can rely on them, maybe why we needed to even inform them. We never, our investigations are not subjected to Baja. Our investigations are subjected to legality. Hence, we mentioned the Home Affairs versus the Public Protector legislation, the SCA judgment.
All right. Okay, just for the sake of flow, can you, obviously, we're not going to go through all those various acts of parliament and so on, and until they become relevant is in our in the evidence. But I think it's important, maybe just for the members, to anchor the rest of this report against the Constitution and the constitutional provision which featured here. Can you just fast forward to page 55, Tsepo? Right. And if you can read out the section 2091 of the Constitution, what it says, and then you'll explain why it was important for this particular report.
Yes. So in terms of section 2091 of the Constitution, any intelligence service other than any intelligence division of the Defense Force or Police Service may be established only by the President as head of the National Executive and only in terms of the national legislation. So this is what it means, and this section is very much relevant to our investigation.
So that's, if you like, is the canvas for the entire investigation, that any intelligence service in South Africa, other than intelligence division of the Defense Force, might be established only by the President.
Yes.
So then it becomes a simple exercise, whether whatever it is you are investigating is an intelligence service or not. If it is, then obviously it falls under this section.
Correct.
Okay, good. All right, so that's then the next section is obvious. The Mail and Guardian, Home Affairs, that's just the relevant case law. All right, now let's get to the meat of the report. So the first issue which you dealt with was regarding, it was for the reasons that you've already explained, the EMEA issue, regarding whether Mr. Kodan violated the Executive Ethics Code by deliberately misleading the National Assembly in failing, it's 5.1. Let's just stay with the report because what that's yeah. Thank you. So the big heading is the issues, effectively.
Yes.
And then the first issue that you then tackle is 5.1, regarding whether Mr. Kodan violated the Executive Ethics Code by deliberately misleading the National Assembly in failing to disclose that he had met with a member of the Gupta family since taking office. All right, take us through that, almost assuming this was the only issue for now that you're investigating. What is, we already know it's an EMEA issue, it's important, it's urgent and all that, 30 days, but how do you then tackle that issue so that, again, we don't have to do that for all the other 6 issues? So let's use this as the pilot.
This matter, the investigator will then, starting point, this has no common issues because it means there were disputes only. There was no issue where Mr. Kodan was agreeing to anything, which we've indicated. Hence, they had to put issues in dispute where he denied the allegation that he lied or misled Parliament.
Mm.
So this will be the first letter which was written to him,
Mhm.
which will then request of him to give us his side of the story. And if that's not the case, sometimes we will then inform the president we are investigating, and then we failed to finalize this matter within 30 30 days. And then we also, when conducting an investigation in this, because EMIA should be the quickest, it's just that sometimes then you'll have to acquire all the evidence, and your investigation should be evidence-based. So we had to get the response, the question from Parliament and his response. And there was then an allegation that when he responded at the Zondo Commission, because he was asked about this, then he remembered that actually he met with Mr. Ambani, the one of the who's linked to the Gupta family and some
And one of the brothers, I
yes.
think, yeah.
So then all this evidence, it's analyzed by the investigator.
Yeah.
Then they have to check what was the question, what was the response, and how he responded. And then is there any gap, or is there any concern that indeed he didn't do what was expected of him? What the Executive Members Ethics Act and Code is saying about that as the minister. So in this particular instance, that's what transpired. So if you go through the report, we are showing what was the question, page 36, 5.1.6.
Six.
And
Okay, where did the question come from?
the question was from Parliament. The member of DA, Mr. Mkhwebane, who asked the Minister of Finance, has he ever met with any member, employee, and or close associate of the Gupta family, and or attended any meeting with the specified persons at the Gupta Saxonwold estate in Johannesburg or anywhere else since taking office? If not, what is the position in this regard? If so, in each specified case, what are the names of the persons who were present at each meeting? When and where did each such meeting take place? And what was the purpose of each specified meeting? Then we got the reply from the records of Parliament where he said, I have not attended any meeting with the Gupta family or anyone else at their Saxonwold estate. I have encountered one or more members of his family at public events on a few occasions, e.g. cricket match. I have met one of the Gupta brothers at Mahlamandlovu around 2009-10, during which a brief discussion on small business finance took place.
Right.
So then we go to the extract from the Zondo Commission.
Okay, just a minute before the Zondo Commission. So because it's here, it now looks like something that might have happened the next day, but I think it's important to show the difference. So that question, which came from Mr. Mkhwebane or whatever, was 11th April 2016.
That's correct.
Yeah. So we can, the answer must have been, we don't have the date, but it would have been somewhere around then.
The answer, yes.
The reply,
I think,
yeah,
I think they have, they are given dates to reply in
yeah.
Parliament.
Yeah, it depends. If it's a written question, it's 10 days
Yes.
thereafter. If it's oral, it's on the day.
On the same day.
Yeah.
Okay. So let's say at West, it would have been still October, November of 2016. I'm sorry, the question was 11th April, May. Yeah. Even given all the holidays and what have you. Okay, thanks. Thank you, Chairperson. Right. And then, so the in October 2018, this is now 2.5 years later. What then happened there?
Then there was proceedings before the Commission of Inquiry on State Capture on the
Otherwise
11th of
known as the
October.
Zondo Commission.
Commission,
Mhm.
correct? Where he said, I had forgotten of another instance where one of the Gupta brothers may have been present at the meeting I had with billionaire and Indian businessman Anil Ambani of the Reliance Group of companies in or about June 2010. So I stress that I do not recall the details set out below since it proved to be a meeting of little significance at the time, but have been assisted in this regard by my former chief of staff, Mr. Dondo Mkhwebane.
Okay,
Yes.
all right. I think we get the gist. So 2.5 years later, he says at the Zondo Commission now, that answer that I gave in April or May 2016, 2.5 years ago, was wrong.
Yes.
And I've been reminded, quote unquote, by the DG. Was this, to your knowledge, ever this correction made to Parliament itself?
According to the information we had during this investigation, it was never made to Parliament. It was only made during this
Zondo Commission.
commission hearings.
Right. And unlike the president, whom at least made his correction, quote unquote, 2 weeks later, this one was made 2.5 years later, and the president made his correction to Parliament, which is where he had made the mistake, according to him. But this one was made somewhere in Braamfontein.
That is correct. Hence, the main issue for us is in such instances, because a person, there's a law, Executive Members Ethics Act, and the code which says they must be truthful to Parliament since they've taken an oath of office. So this is raised at the inquiry at the Zondo Commission. And by then we didn't have any record which shows that they also maybe made corrections. And I think, again, this still shows that Parliament should be considering the amendment of EMIA very seriously.
Yes.
To address and compel people that, okay, if you have not included the information, but you definitely must go back to Parliament and maintain the decorum of Parliament and the respect.
Yes, that's, and possibly within a particular period.
Yes.
Surely not 2 or 3
2
years
years down
later.
the line.
Okay. And this is the kind of issue that in the CR17, he had this meeting with Indian businessman, Mr. Ambani, and there was one of the Gupta brothers, but he forgot, and his DG reminded him, and he says there, he does not recall this Gupta person being there, but he may or may not have attended something like that. I think that if you go to 12.3. I want to do 3.5.6, Chairperson. So Mr. Mkhwebane has advised me that he recollects that Mr. Ajay Gupta was present at the meeting. I do not recall him being present. I wish to refer to the Commission to annex whatever, which is my response to a Parliament question from the DA. It appeared in my written response that I do not make mention.
It is apparent.
Yeah, it is, yes, it is apparent in my written response, thanks, Chair, that I do not make mention of the 2010 meeting with Mr. Ambani of the Reliance Group, which a Gupta brother may or may not have attended. This is simply because at the time of this of submitting the written response, I had no recollection of the 2010 meeting with Mr. Ambani. Okay, I can't claim that I understand that, but that was the answer that there's, I don't know which part he recalls, which part he doesn't recall, but that a Gupta brother may or may not have been at that meeting. Now, okay, this parliament now, I'm talking about this committee. What must it make of this? I mean, how do we know what Mr. Kotan was intending to say here?
Maybe let me start by saying, go back to the question. I think again, it's for future lesson, when they respond to questions of parliament, because the question, it says, has he ever met with any member, employee,
5.1.6.
and or
Hmm.
so close associate of the Gupta family, and or attended any meeting with the specified persons
Hmm.
at the Gupta section world, 1, anywhere else, 2, and then the other parties, what are the names of those people?
Hmm.
So the response was only addressing the Gupta family and anyone else, but at section world, not even mentioning. Well, he mentioned that anywhere else, those people he met at a cricket match and Mahlamandlovu. So the issue here was, then he recalled that there was a meeting where he met specifically this Gupta associate, and it was not at Saxonwell, but yes, it was somewhere else where he met. So the main thing here was that he should have, well, though the rules don't provide, corrected that to parliament, but he just remembered outside of parliament that he met this particular individual. So I think his explanation is that. But then here we were trying to say to him, you either intentionally or inadvertently misled the president, or in fact here in this case, the legislature, because that's what the executive ethics code is saying.
Yes.
Or
Okay.
the 2007, which we were using.
Well, okay, but the way you framed the issue before, it was whether he misled, there was no inadvertently.
Yes.
So, but anyway, in fact, what I was getting at is really, okay, given that Mr. Kotan did not come here, will we ever know what he was trying to say there?
Yes, because he's explaining himself, and hence I'm saying that even his answer to that question, if he was here, he would have clarified further to say, okay, Roman figure 1 says this. What is your answer? Because normally I think that's what they would expect them to answer. But then it was just a lumping everything together, which was supposed to say, on this date, this is what no member of the family, no meeting with the associate, no meeting at Saxon World, or meeting at only met at Mahlamandlovu and the cricket match. And this is the particular person. So this was going to help if he was also here to explain to the committee what he meant specifically about that, like general answer to the matter, and then later clarifying to the Zondo Commission. So I don't know whether this committee will be able to make any conclusion based on this if he is also not presenting what he actually meant by this.
Maybe
Okay.
just before
Sorry,
you,
Chair.
before you proceed,
Yeah.
just on that question and the gaps that the PP is identifying, because I'm not sure if you were able as that institution to follow up with the member, because normally that would have been an answer back to Parliament to that member. And rules do assist that if there are gaps, then there gets to be follow-ups on those if questions have not been fully answered, because that's a requirement of Parliament. So I'm checking
Yes.
if having looked at that answer from your side, whether there would have been a conversation with the member to say, because if the member has not taken up the issue thereafter, the matter is closed then.
Yes. Yes.
So it
That's
can't be taken by any other
Yes.
external party in that way, in terms of the rules.
Yes.
So just to make, unless the situation that says the member was not happy, was ignored, and all of them, that gets to be a
Yes,
different
no.
case.
No, that's a fair question, Chairperson. I think, yes, I think maybe we can frame it like this. The chair is right. It's all very well to say now, well, Mr. Mkhwebane maybe did not come back to Parliament, and who can speculate. But I think the question from the chair is specifically from the PP's point of view. In your interactions, whether it was Section 7(9) or whatever, was that question sharply raised with a member as to, A, did you correct the thing in Parliament? And if not, why not? Was there such an interaction to your, in the Audi processes?
Chairperson, the Section 7(9) notice, if we go to it, it was raising all these inconsistencies and the gaps. So it was the members' also responsibility as well to say, well, the DA person was happy, Parliament was happy, therefore I never went back to clarify the issue. But hence the issue I raised yesterday about the Section 7(9), most of the time people think, I've responded or I don't agree with this, instead of also helping, because it's just helping us with our investigation. And if that was done, possibly it was going to be a different response.
Thank you. All right. Now, the rest of it is what we went through yesterday with the Busasa report. You apply the executive ethics, you refer to Section 96(1), 96(2), 23A of the executive ethics code, and so on. And then once you have then applied those prescripts to the material that you have, then you reach your conclusion. So just take us through that. And I mean, I know it's not as simple as all that. In between, there's all the things we've just spoken about, Section 7(9) and toing and froing and so on. But just take us through then how you arrived at the conclusion and what the conclusion was.
So in all our investigations, you have an issue, we have issues, common cause issues, we've got issues in disputes, then we apply the prescripts. This you've just gone through, the legal framework. And then from there, we then come to the conclusion. In applying the prescripts, did the implicated party complied with the prescripts which have been mentioned there? So, and after giving them an opportunity and audit in terms of Section 7, subsection 9, also they would bring additional information to us, as I've responded to the chairperson. So we analyze all that information, and this is done by the investigator. For instance, Bianca and Rodney deliberating on the matter. When they come to me, I will say, what is the progress? How far are you? And then comment where they need clarity, and then they finalize the matter as it was finalized. So the conclusion was then the fact that, having not disclosed that he had actually met a member of the Gupta family and an associate thereof in 2010. So he conceded to that. And then he argued that at the time his officer response, he could not recall, or he had forgotten about the meeting that in which Mr. Ajay Gupta was present as such an occasion. And it's not only the fact that Mr. Ajay Gupta was present. We should have also went further in that his response is accordingly misleading to Parliament. It does not seem like a bona fide mistake, because he should have done that and clarified the matter. And again, it goes back to the issue of responding to Parliament, the issue or the intention of the executive ethics. Ethically, when you respond, don't just rush to respond. Why was he not reminded by the Chief of Staff? Because when you're supposed to respond to Parliament, normally those are sent to the minister. The minister will have to sit with the possible ministerial staff. If it has an impact with the department, the DG must also check with the staff, give me information. That with the intention of making sure that ministers, because they're executive, they account to Parliament. It means you must respect Parliament. You must make sure that you are transparent, you are honest in your response. So that's what he picked up, and that was the finding based on the facts before us, the responses and the documents we received from Parliament on this matter.
Right. Now, in relation to this, sorry, Chair. I think what I'm going to do, let's move to the next issue, but so I'll come back to this in a different format, because what I intend to do, Chairperson, to try and save time is, once we've done an issue like this and gone through it as here, is then to juxtapose that with whatever the finding was in the judgment and then move on, so that we don't have to then retraverse the issue when we do the judgment itself. Yeah. But for now, can we just move so that was the finding, and then the next issue is at 5.2, support, which is page 40, regarding whether during his tenure as SARS Commissioner, Mr. Adv Mkhwebane established an intelligence unit in violation of the South African intelligence prescripts, and if so, whether such conduct constitutes maladministration. So now we're getting to the so-called rogue unit issues, having disposed of the EMEA issue in the way that you've described. And this is what we called, in shorthand, Chairperson, the establishment issue, as opposed to the procurement or recruitment issue and so on. Yeah. Okay. So tell us, firstly, what were the parameters of this issue, the establishment issue? What was said, what you found, and what you took into account? And maybe in this one, fortunately, there were common cause issues, so you used your normal format here. Not necessarily word for word or blow by blow, but just take us through the highlights.
The highlights of this this issue had common cause issues. And you see the 5.2.1, we indicate that it was not in dispute that the allegations that the unit was unlawfully established, and that it has been in the public discourse. It was something which was discussed by various institutions, legal experts, so that is acknowledged. And but the issue of my determination was whether the institution or the unit was in violation of any legal prescripts.
Yes.
So
no, I think the part that you jumped might be the most important for the purposes of what's going to follow later. That you say that it was in the public domain. I think everyone who's a South African knows that. But you also refer to the reports.
yes. And then when this matter was brought to the attention of SARS, because again, you see, we are investigating SARS. And when we investigate SARS, it's because Mr. Mkhwebane was the commissioner of SARS, the accounting officer. So we also then show that it's common cause what SARS has acknowledged in their responses, where they indicated that there was a unit and which was collecting information in respect in respect of compliance with tax and custom laws. And this was confirmed by Mr. Pillay when he responded originally to the public protector when they were investigating the human resource related complaint of 2014. And the name of that particular unit, what was it called by then? Because you'll see in the report, we are even showing you step by step how the unit changed from one name to another name to another name to another name. But we will also show that the same individuals, the same modus operandi, the same equipment, which were the subject of our investigation.
Good.
Yes.
Yes, good. Hence we just call it the unit. So
Yes.
without, because one, it was this, the CBU, the XYZ and what have you, but it, as you say, it was the same unit here. All right. Now, then at 5.2.5, one of the criticisms when you get to the judgment is that you ignored or did not take into account the Nugent Commission.
Correct.
Yeah. Well, then against that criticism, can you comment on what is contained in 5.2.5?
Yes, so this is the Commission of Inquiry into Tax Administration and Governance final report, which is the very same Nugent report. And we have captured the information that we receive a response from SARS. And SARS provided us this response where they were saying the Nugent Commission found that there was only a question why such a unit was considered to be unlawful. It's not clear. That's what the commissioner said. While a National Intelligence, a Strategic Intelligence Act prohibits the covert gathering of certain intelligence that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax, which indeed we agree to that members of the unit might at times have acted unlawfully. SARS employment policies might have been breached, that members might unlawfully have acquired and used equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish such a unit to gather intelligence on the illicit trades, even covertly within limits. So that's within limits. It's very critical. And I must say, I agree with this. You will see later in the observations where I was very clear, because it's as if I'm now this person who doesn't want SARS to do their work, because their work is allowed for them to do that when they investigate information relating to tax evasion, illicit trade. Then he says, indeed, that was in view expressed to SARS in late 2015, which seems not to have been made public by SARS. An opinion was furnished by to the former commissioner of SARS in 2015 in response to the findings of a panel chaired by Advocate Skakane, by Trengov SC, by Advocate Ngumalo, who advised SARS that it was said to be unlawful by a panel chaired by Skakane, but I find nothing in its report to persuade me why that was so. That's what he says. Advocate Skakane was asked if he could elaborate, by his reply took it no further than what was said in the report. Then he goes to the Judge Kroon, the Judge Kroon Advisory Board, which reported to the minister and issued a media statement saying the unit was unlawful. But the evidence, he told the commission, that was not a conclusion reached independently by the board, but had been adopted from the Skakane. So that's what the Nugent Commission was saying, which I will show now why it this week had to capture it and indicate that, yes, it was said. And we will show why it's differently to what we were doing as the
Yes.
public protector.
Okay. Yes, that's okay. That's exactly what I want to get into. Well, we'll leave for legal argument whether the statement by Judge Nugent where he says something is not clear to him means that it's unlawful, or rather it's lawful. So, but I want to get exactly to the point you're making now about whatever the terms of reference of that commission were. We don't know for now, but we know that they're not the same as your complaint, as it were. Now, here's the thing, because this Nugent Commission, when you are criticized, is trumpeted as, shall we say, an absolution of the unit. But if you go to paragraph 9, now wearing the hat of the public protector, not of Judge Nugent, can you overlook the things that he says? He says that members of the unit might at times have acted unlawfully, that SARS employment policy might have been breached, that members might unlawfully have acquired the use of equipment, all of which came later to be alleged. Let's just take those 3 things. If he's now acknowledging, let's say, that those things might have happened, and for him, he brushes them aside. Now, for the purposes of your investigation, if you found those things, that employment policies were breached, members acquired equipment unlawfully, and so on, what finding would you have to come to?
You know, it's a concern because he never conducted an investigation.
Yeah.
Whereas possibly he was reading some of the affidavits and statements, which he was seeing that maybe that has been done. But from my side, I wouldn't just ignore such, especially being an investigator. A complaint is lodged. I'm there to make sure that any state functionary is compliant to the laws. Similar applies to, we'll still go to the judgment, which is criticizing me about this. The fact of the matter is, when the public protector investigate, and Wes being advocate, Judge Bakwa, who was the public protector, who knows our mandate clearly, when there's violation of any supply chain policies, when there's violation of the recruitment policies, and when there's violation of the law that this institution was established and it conducted its work contrary to what it was expected to do, I wouldn't definitely just brush it aside as the public protector because I'm an investigator. His terms of reference were dealing with broad issues of SARS. I was dealing specifically with the violations of these prescripts because of a complaint which has been lodged. So I wouldn't just ignore the information and brush it aside and say, because Judge Nugent has said these, and it's a commissioner and who was not investigating. And as public protector, we were investigating because we had to check what happened, what should have happened, whether the violation of the prescripts and whether there's any gap. And how can we remedy this? Because our intention as well, going forward, is to remedy, and acknowledging that the public protector's remedial actions are binding. Going forward, the Commissioner of SARS, if these people who are surely interested in making sure that such things are not repeating themselves, they will learn from this, they will avoid doing this going forward.
Yes.
Surely. Yeah.
Okay, thank you. Then that then takes us, so I think it should then be clear that you engaged with the Nugent report at whatever level. You didn't ignore it. Yeah. Now,
Definitely.
the next issue then is the important issue of the Trevor Manuel memorandum that you referred to earlier.
Mm.
And again, Chairperson, to save time, I won't go to the actual, we've made references to it with Ms. Mkhwebane and so on. So we'll just use it as it is quoted in the report, so that we'll
Correct.
just move along. Yeah. The references are the same as before. Right. Now, that memorandum plays a crucial role in your report. And I'd like you in particular to what we know now in this committee about it is the fact that it was written to Minister Manuel. It was written by Mr. Mkhwebane, and he was requesting certain things. But I'd like you to just read 2.1, which I think is the important part of that letter or memorandum, and then comment on what it says to you.
This 2.1 says collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity.
All right.
So this paragraph is very clear that SARS and under Commissioner Mkhwebane, they knew that they don't have the legislative mandate to deal with this or to establish such a unit with such capabilities.
Yes. And Chair, I'd like to highlight, because Ms. Mkhwebane testified that the key activities, and we'll deal with that when we deal with the operations of the unit. But the key things, which the red flags, were interception and surveillance. That was the evidence of Ms. Mkhwebane, and where she said those and it was also the using of a jamming device and so on. But those were just a few things that would, even for someone who's not familiar with the intelligence world, start giving you signals, as it were. Now, I want to zoom onto the first sentence. I see the point you make about the legislative mandate. That's fine. But it would seem that even at that early stage, there was an appreciation of the kinds of activities the unit performs. And so what do you read into that statement that says collecting tactical intelligence, which is what they were doing, invariably means penetrating and intercepting organized criminal syndicates?
This meant especially the interception of organized criminal syndicates, which they should be doing, especially if they violate tax-related matters and customs and illicit trade. But then it's very clear that the how part of it should be done by the institution which is allowed to be doing that.
Okay.
I think that's what it was meant to do.
All right. And then in case there's any doubt, the next sentence, 2.2, then says, discussions are taking place with the national intelligence to supplement SARS intelligence capability. The word supplement there, does it mean there was no intelligence activity at SARS?
This means there was intelligence, there was the SARS intelligence capability because they wanted to supplement it.
Yeah. All right. So let's then assume then that it will be considered by anyone that firstly, the interception activities taking place or at least envisaged, and that there was some existing intelligence capability. And in any event, if this had nothing to do with intelligence, why would this memorandum be reached with NIA, not Department of Water Affairs and so on? Why else would it have been reached with NIA?
I think they acknowledged and they understood that it's not falling within their mandate. And they had to make sure that they approach the institution which is supposed to do that. And I think they had at the back of their mind section 209 of the Constitution.
Right. Because, thank you, because we know that, well, everyone knows that the institution in South Africa that does comply with section 209 of the Constitution, in other words, which conducts intelligence services by, and which is governed by national legislation, is NIA and Defense Force and the police, I think. But we know those institutions, correct?
Yes, in terms of section 209 is the defense intelligence, subs intelligence and state security.
Yes, good. All right. So then another important issue, and Chairperson, I'm really raising this just for context, in the mode of what I was saying yesterday, where I said the public protector reached the same conclusions, for example, as the Chief Justice. And then, yeah, so I'm making that kind of comparison. Let's go to 5.2.8 and tell me what your comment is about this. This is now someone, sorry, I almost said comrade there. But Mr. Jabu Muleketi, who was the Deputy Minister of Finance, the letter was clearly sent to both him and Minister Manuel. And Minister Manuel did approve, as you already said, and so did Deputy Minister of Finance Muleketi. But interestingly, he inscribed, and again, Chairperson, I won't take us to that letter, there was some handwritten inscription by Muleketi on the letter.
Correct.
So he approved, but as it normally happens, approves with comment. And his comment is reflected in your 5.2.6. And it says, Deputy Minister of Finance noted and stated that, quote,
0.8.
Oh, I'm sorry, it's 8, yeah, sorry, it's my eyes. 5.2.8, it says, Deputy Minister of Finance noted and state, no, sorry, let me read the whole thing. The recommendation was supported by the General Manager, Enforcement and Risk and approved by the Deputy Minister of Finance and the Minister of Finance on 22 February 2007. The Deputy Minister of Finance noted and stated that, quote, supported. However, this is a strange way of executing what I consider to be the mandate of NIA. It seems as though it's an add-on rather than part of NIA's mandate.
Correct.
Okay, now, this is now the Deputy Minister, not you, not anyone else, making their own observations. Firstly, what do you read into that, and what do you think he's saying about this whole unit or the project?
This is because when you read, when he reads this submission, indeed, it's very clear that this mandate is the mandate of NIA. By then it was called NIA, which is state security now. And he's also saying it seems as though it's an add-on rather than part of NIA's mandate. So he's saying what we are saying, that it means there was that unit operating. Again, Chairperson and SC, I want to just stress that it will show that SARS has the capability to investigate within their mandate. Here, it's very clear that it was concerning or it was questionable that it's as if they are usurping the responsibility of another institution. So this is also a concern that this is a mandate of NIA, but it seems as though it's an add-on rather than part of NIA's mandate. But that add-on, it means it's something which is questionable.
All right. Chair, okay, I'll find there's a section in your report which I think you've referred to it almost twice now in giving context. So I wanted
Yes.
us to get
I'm
it
trying
out
to
of
do
out
that
of the
because,
way. Yeah. All right, we'll find it now. All right. So Mr. Muleketi then deals with this. Then you then go into, remember you cross-referenced that this was a matter of public interest and topical issue in South Africa and so on. Then you deal with the various reports. You refer to the KPMG report at 5.2.9 and 5.2.10, which I think is then the gist of your logic, as it were. Can you take us through that?
So point 10, the 5.2.10, this agreement meant that the two parties recognized that intelligence gathering was not within the powers and legal mandate of SARS. It also meant that there would be instances where SARS would require access to specialized surveillance. So it was just making sure that from the reading of all this and the said agreement, they were supposed to be complemented by state security. So it was not the responsibility of SARS to deal with that particular surveillance, or they didn't have that specialized capability, which doesn't fall within their mandate. And 11, it means we then go further that this MOU did not materialize as intended by SARS, and then resulting in SARS continuing to develop its own capabilities. And I think 12 still goes further to show that SARS approached Minister Ronnie Castrils, and where they were still wanting to requesting an approval for the establishment of this deep COVID capability, which will give both NIA and SARS to work to collaborate.
Yes. Okay. Now,
so this was not approved by the then Minister of Intelligence.
Yes. Okay. Now, yes, I found the place where I think that you were burning to explain as part of the context, which we jumped. And I think this is important, Chair. If we can just go back to 42, I'm sorry, to page 10 of the report.
The executive summary.
Yeah, page 10.
Okay.
And I think this might well be the most important observation, just to put into perspective for the committee, but also for South Africans and for anyone who might say that you did not want SARS to have to be chasing tax dodgers and all sorts of people who might have been legitimately targeted by the unit.
Correct.
So if you can just read out the
So it's observations and again learning from the state of capture judgment of the Pretoria High Court, where they said observations can also be regarded
basis,
as, yes.
a basis for remedial action.
Yes. So my investigation of the establishment and activities of the intelligence unit by SARS should not be viewed as stifling the effectiveness and efficiency of SARS in their investigations into tax evasions and the curbing of illicit economy, but is to ensure that they do not encroach in the territory of the state security agency. Perhaps consideration should be made by the two institutions to conclude a memorandum of understanding so as to have collaborations as and when the need arises. So this was putting it out there, and as well to make sure that I'm not against and I support the issue of them having to conduct illicit activities. And as the chairperson, we will go to in the report where also it is very clear in terms of the South African Revenue Tax Act, that investigation unit, what powers it has. So you'll see when we deal with it under legislative framework, and it's very clear what they are supposed to be doing and how they should be conducting their investigations.
Yes.
Yes.
So yeah, so then it would seem that your job was much a simpler one than all these dramatic things that are suggested. You were not passing moral judgment as to whether SARS can collect intelligence or in whatever way they wanted, but simply looking as to whether in so doing there were any breaches of our laws, constitution, regulations, and all that.
That's
Procurement
all what
policies, and so on, but not necessarily to stop the unit itself.
That's what our intention is, and to support them as SARS, do things within the law and the prescripts of the law, do not perpetuate unlawfulness, be compliant to the law as it stands. So that's all what we are doing, and that's all what we were intending to do with this report.
Yes. And if you extend that to a simple issue like the recruitment of personnel, again, you didn't say, no, you must employ this one, don't employ this one. I don't like this one, I don't. It was a simple question of whether those people that they want to employ were employed in terms of the applicable HR policies and so on.
That is definitely correct, because if you check our investigation, simple issue, what is your policy saying? Yes, possibly because we dealt with the issue of these people, it seems as if they were seconded. But what is your policy saying about that? Comply to your policy. If you want to second them, do that. If you want to advertise and get skills from outside, what is your policy saying? Follow the normal recruitment, your recruitment policy. And if you, for instance, possibly their policy doesn't provide for secondment, that will be a thing where we say, amend your policy so that you have a secondment and then you are compliant. That's all what we were intending to do with this process.
All right. And at the risk of stretching the point, if you apply that same logic to the equipment, the procurement of equipment, what were you looking for there? Again, whether it's a jammer or whatever device, would that have been your concern insofar as procurement is concerned, or what were you looking for in under that heading?
I know we want to move to that, yes, but there's a point I
No.
want us to
Oh,
come back
okay,
to.
sure, please do.
Yes. Maybe let me start with that because it still deals with the recruitment.
Mhm.
Page 44, it deals with the unit was staffed by what kind of skills of those individuals.
Sorry, you're reading at 5.2.15.2.
Point two, yes. The unit was staffed by former intelligence,
Sorry,
law
just a
enforcement.
minute, Bibi.
Okay.
5.2.15.2.
Page 44. So this deals with the legal opinion of Advocate Mkhwebane SC and Advocate Normal, who gave a legal opinion. You know, okay.
Yeah, there you are.
Yes, because they then they were requested to give an opinion on the
Point
Sikakane
15.2.
report.
Sorry. Yeah.
On the Sikakane report. So the legal opinion then picked up that the staff, because we're dealing with the issue, I want us to just conclude the issue of the recruitment. It was very clear that the people who were recruited or who were staffed by in that unit were former intelligence, law enforcement, and tax professionals. And it conducted investigations using methods, techniques, and equipment normally used by the intelligence and law enforcement agencies.
Okay.
So those are the red flags. Now come to the SARS investigative powers, which I mentioned earlier. Oguti, what is the Tax Administration Act says about investigation? What SARS, because this is also at the core, SARS powers to conduct various types of investigations for the purpose of the administration and enforcement of tax legislation. So these investigations range from the least invasive to the most intrusive. So this included the request for information from a taxpayer, arriving at the taxpayer's premises without prior notice, requests for a taxpayer to submit for interviews, conduct audits and investigations on the premises for any person by prior notice.
Yeah.
So their investigation powers as well are only limited to what the tax legislation is saying. So they may not do any other investigation that intrudes upon the privacy of others without the statutory powers to do so.
Okay.
So this is what they were expected to do. So I'm just showing you that when we take it further, this is the opinion, and the opinion is also acknowledging that the people who were working there, what kind of people were they? But as public protector, we didn't just take that and say it's gospel truth.
Yes.
As public protector, then you'll see on the recruitment, because we wanted the names, we wanted to know, was it advertised? If it's not advertised, you seconded them. Where is proof that they were seconded using the proper process? Because when you second somebody, there must be a submission, like that submission which was requesting funding, because those are the internal documents of SARS.
Okay, thank you. And I think, thank you for highlighting that. But I want to really situate that response to, again, to simplify it really. As a public protector, I'm a member of the public. And the issue is, so where do you come in all this? Why are you involved in this as a public protector? And I think that issue about the privacy of citizens, then which was highlighted by the two advocates, come through. And the Section 209 connection. Because section 209, remember, this is the constitution, it's not legislation. So what
Correct.
it's really saying to me as Mr. Citizen is that as I walk around, I must be sure that all sorts of institutions don't have the right to establish private armies or private intelligence officers. That the chairperson can't just wake up tomorrow and say, okay, I'm now going to have an intelligence division of this committee without which can spy on me or my attorneys or whatever. Isn't that the essence of all this? Is that, and I want you to unpack that. What is the interest of the public protector in all this? Because the SARS could say, well, why do you care? If we want to have an intelligence unit, it's got nothing to do with you. It's we are collecting tax and leave us alone. Where is the public protection angle in all this?
Remember the public protector's mandate in terms of the constitution. Again, investigate improper conduct in state affairs, but that is done with the intention to protect the public. Public Protector Act is saying we investigate abuse of power, and any institution which is performing public function, they should perform the public function and be compliant to what the constitution and the various legislative prescripts are saying. So in simple, straightforward work of the public protector, SARS, do your work, be compliant to your own laws. Do not encroach on other institutions' legislative mandate, but as well, even if when you do your investigations and you are within your right to do that, also still comply to your law. So basically the public protector, that's all what we do, because we don't want a situation where things are then, normally I would say, we investigate maladministration. We should be dealing with that at a very early age, because if we pick up such things and we don't learn from them, then it means it will perpetuate into a situation where the citizens' rights will be violated, not even the public's rights will be violated. Your rights to privacy, even if it's not relating to tax, but then you find that the unit will then investigate you or access your information or even follow you. So we're still coming to the operations of the unit and the information which was before us when we investigate. So is to protect that, because we want a state where you respect the constitution irrespective of who you are.
Yes.
It was purely to protect the public and nothing more, nothing less.
Yeah. And when we deal with the judgment, we'll deal with all those issues.
Yes.
Whether really, in your view, then if you are judging this kind of thing, even as a member of the judiciary, should you be nitpicking on technicalities and all that, or the whole issue of the protection of the public and the dangers that might arise? Should a unit like this be left to roam around the country?
You know, the justice system or the judiciary or the justice system, I know we said they are focusing on the papers before them, but I think in whatever they do, they should also having that broader perspective to say the judgment which we are issuing, what impact will they have to society at large? Because the issue of justice needs to be seen to be done. There's a number of issues we'll speak about on those issues, but as a judge adjudicating this kind of a matter, you should then be worried that If this is left unattended, we just focus on section 9, we just focus on just saying the public protector was biased. But what was the public
Or
protector
whether it
trying
was 2 years later.
there's section 6(9),
Mm.
the issue of that. But what are we saying about this unit, which is not compliant, and public protector is trying to remedy that SARS, put your house in order, and any other institution which is not mentioned in section 209.
Mm.
And the president doesn't know about this and hasn't given authority for that institution to proceed, like Parliament speaker the next moment saying, now I'm establishing this unit. Then it means anyone can do that. What are you doing to the issue of invasion of the rights and privacy of people? So I don't think that's the country would want to have.
Okay,
Okay, thanks.
maybe just to indicate before we take a 2-minute break,
Mm.
I think Advocate Mkhwebane, earlier on the day, you've nicely listed the headings.
Yes.
On this is about 5 or 6 of those.
Yes.
I think we've done with EMEA. We're
Yes.
now on to the establishment. So it will be important when you come back for us to hear what is the summary of evidence on that
On that,
establishment.
yeah, fair enough.
And then we
Thank
go,
you, Chair.
go to the rest.
Thank
But
you.
can we take a 10 minutes tea break? Thank you.
Recording.
Thank you. Welcome back. Thanks.
Okay.
From the tea break, we get into our last session. Advocate Mbofu, back to you.
Thank you, Chair. Right. Okay, I think I'll continue to use the report as our source document until it's not possible to do so. But because what I wanted to do in rounding up this second issue was to refer to Mr. Kodan's section 7.9 response, where you'll remember that I put it to Ms. Mkhwebane that his response really almost amounted to what I called loosely a confession that yes, indeed, he was involved in the establishment, and then he makes certain remarks, but we'll get to that when we deal with the section 7.9. So far, we were at the point where we were cross-referencing the remarks of Mr. Muleketi, and then UPP then took us to another cross-referencing, which was to the Trengov SC opinion.
Yes.
And then we then spoke about what we call the public implications of this and section 209. Now, we will, okay, maybe let's do this. At 5.2.1.15.6, still in the Trengov SC opinion.
Yes.
And again, I'll just be selective because I think we did a similar exercise with Ms. Mkhwebane. Just to give a perspective to someone sitting at home and listening to this, the type of activities used by the unit at that time, what they included according to the Trengov SC opinion. On that list, can you look at and juxtapose that against what you were saying about the interests of citizens?
Okay.
Item A.
Chairperson, I just want to still insist that this opinion of Trengov and Mumal was also saying, which we agreed to, that SARS may not do anything which is outside of the tax law. So item A was the surveillance of individuals, which the special projects unit and analyzed by the legal opinion team included the surveillance of individuals. So that is what the opinion was saying.
Yes.
This unit was doing.
Okay. Right. And as I said, those are some of the key what's called red flags that Ms. Mkhwebane identified. Surveillance, interception, and so on. And let's go to item G as to what the unit was also doing.
Listen into and or electronically record third-party conversations by using listening devices.
Yes. Item J.
Accept information from a person while knowing.
Sorry, it's my eyes. Item I.
Okay. Obtain information from informers on the understanding that the identity of the informer will not be revealed.
Item J,
Accept information from a person while knowing that information was acquired unlawfully or illegally by the person.
right. Now, the question I really want to ask is, again, it's just a random selection. Well, it's not random, a cross section of some of the activities of the unit. But I'm just saying, what message, if you're trying to check whether this indeed exhibits signs of being of the intelligence world, what impression would you get if a unit was involved in such activities as just the 4 that we picked out?
Well, on the face of it, it's concerning because you cannot just accept information from a person whilst knowing that that information was acquired unlawfully and illegally. I mean, we have laws in the country which needs to be respected. And even K, I mean, it's used other abusive practices or threats. So it means to secure a particular outcome by consent. And their investigative powers should be within the limits of the tax administration law. But then those are the things which were picked up. And even the fact that the interception of and listening of people's information, that also should be done within the law, because we dealt with that legislation which needs the approval of the judge to do that. So that's the information which, even besides the Skakane report, but the legal opinion on conducting and checking all the available information, that's what they've picked up.
Yes. All right. And then the 5.2.15.8,
Yes.
I think that's the one that deals with the permission by the judge. What was then the conclusion of the Trengove
Legal opinion.
opinion?
He says, however, from the evidence reviewed by the panel, such officials were prohibited in terms of the regulation and of interception of communications and provision of communication related information act from interception communication of individuals under tax investigation. So they were prohibited to do that.
Okay.
Because possibly it was clear that there was no evidence that they acquired the relevant approval
From a judge.
from a judge.
All right.
Correct.
Then the next section deals with the Skakane report. I'm not going to deal with that now because I want to deal with all those reports tomorrow in one section, so that we don't hop around among them. But what's your investigators, your team, had access, just to confirm, they had access to the Skakane report, correct?
That's correct.
Because the Skakane report, as we know, was produced in 2014, I think. Your work was being done in 2018.
Correct.
Okay. Now, so they refer, one of the reasons I don't want to go through that, they refer to some of the material we've already spoken about, the Trevor Manual memorandum and whatever you.
Yes.
But then the 5.2.23, that's on page 48.
Yes.
This is where there seems to be then a coincidence of conclusions between you and Skakane, at least. And I'd like you to read out, that's their kind of conclusion on the establishment issue.
Yes, where it will seem that at this stage, SARS recognized that it had no statutory authority to collect intelligence.
Hmm.
And then the report found that there was prima facie evidence that the SPU engaged in functions that properly belong to other government agencies and that SARS had no authority to perform.
Hmm.
And there was a real possibility that the SPU undermined the work of government agencies tasked with investigation of organized crime and the collection of intelligence.
Yes. Yeah.
So that's what
Their
this-
conclusion. Yeah.
Yes.
All right. Now, 5.2.25 is important because it provides the platform or transition from, as it were, Sikakane to the well-known IGI report. Can
Correct.
you read that out?
The report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. So can I elaborate on this?
Yes. In other
Um,
words, the Sikakane report.
yes, this Sikakane report.
Mm.
Because of the picking up of information where they have moved out of their mandate, they encroached into the mandate of SSA. So I think also that creates a lot of confusion because people say, but this unit was not an intelligence unit,
Mm.
but their activities were in such a way that it fell directly within the mandate of SSA. And I mean, taking the approval, the approaching of Minister Trevor Manuel and all those. So hence, in a meeting we held with the Inspector General of Intelligence,
Mm.
Dr. Dintwe, on the 31st of January 2019, he confirmed that the Office of the Inspector General of Intelligence had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof.
Yes. All right. Okay, Chair, I'm just flagging that issue. We will come back to it. You'll remember that right at the beginning, I can't remember how many days into this committee, there was a transcript, or rather an audio material that was played by the evidence leaders, which related to that particular meeting.
Correct.
Yes. And that meeting, there seems, again, it goes to this whole issue as to whether anybody really was under any impression that there was no report in your possession. But we'll go through that recording. What we will do, Chair, is to provide a transcript. In fact, I don't know, I think that transcript is already part of the record.
It was done that. If you could, sorry, Chair. There is a transcript of the record. that
Yeah, it's
was-
1/4 page. It's bundle K, item 13. Maybe let's just display it because I just don't want to get into it now. But bundle K, item 13, page 1466. Yeah. All right. Just show the attendees.
Yes.
Right, okay. So this is a meeting that is referred to in that paragraph you just read. And who was present there?
It was myself. It was Mr. Nyembe, the late Mr. Nyembe. It was Ms. Mkhaladi, the executive manager.
Mm.
It was Mr. Rodney Mataboche, the chief investigator.
Mm.
It was Advocate Jay Kavenda from the legal advisor from IGI,
Mm.
and Mr. Ephraim Kabinde, my PA.
Right. Okay, and this is the same Mr. Cavenda who has recently submitted an affidavit to this committee, correct?
That's the same Miss Kavenda, yes.
Miss Governor.
Is a miss.
Let's say Advocate Governor. Yeah.
Yes,
All
it's
right.
is a miss.
Her affidavit is you have read, and I indicated to the evidence leaders that you would want her to be called at the appropriate time, but for now we're working on her affidavit as it is. I just want to we'll come back to this transcript, because I just want to deal with your statement there that in that meeting, effectively, they confirmed the existence of the report. And I think they said the custodian was the minister and so on. But
That's correct.
yes, we'll deal with that when we do all the reports themselves.
Okay.
Anyway, then you deal with the interviews with the Minister of Security. What was that all about?
And that was still my effort to assist the team to determine the veracity of the allegations of the existence and the activities of the intelligence unit. I sought more information from the Inspector General of Intelligence, and information, this information was attributed to a report by the former intelligence. So I subpoenaed the minister. I had a meeting with the minister, still with the intention to say, and I informed the minister that I have this report, and this report, I want to make sure that I get it legally from the institution which produced it. In fact, the custodian of the report, because IGI informed me that the minister now is the custodian of this report.
Right. Now, again, and this now talks again to the allegation that you were concealing that you have this report. If you got 529, 530, and I think 532, you use the word that the minister undertook to request the Director General to avail the declassified copy of the report. The emphasis is on declassified. And then you said, I have yet to report to receive the report as promised. And then at 5:30, you say again, I will be requesting the new minister and at law to avail the declassified report to my office. Then 5.3.32 again, I've since requested the President Ramaphosa's assistance in facilitating the availing of the declassified report by the Minister of State Security to no avail. Now I want to, in all those, when you are saying you wanted the declassified copy of the report, what was the emphasis between that and whatever you had?
It was because acknowledging that the report is a classified document and how to treat a classified document, and also understanding as well from the meeting I had with the IGI and in January, where the key issue was how do we make sure that their sources or the agents are protected? Because remember, this report was not only dealing with this SARS unit, was dealing with other information and other individuals who are supposed not to be exposed. And as well, the very same issue of how the agency is operating. Now, my insistence of the declassified report was acknowledging that I would want to use that document. And remember, in the sources of document which I've indicated, I said there's some documents and equipments which were blinded and documents which I cannot disclose. So it was all in the intention of making sure that as the pipe protector, I also operate within the provisions of the law and I act responsibly in protecting those sources and covert agents and operators and how they are operating. So all this were my efforts to get the document which is declassified from state security to no avail.
Okay. Then you then say at 5.2.33, in light of the above mentioned and the terms of powers vested in me by section 181, 2 and 3 of the Constitution, I have it on good authority that the findings of the OIGI report inter alia were that. Then you say what the findings are. Firstly, SARS created a covert unit using intrusive methods and so on, in violation of section 209. And then you say the establishment was illegal. And then the IGI recommended that criminal charges be investigated against Mrs. Godan, Pillay, Van Lochenberg, and Richa for the establishment and involvement in the covert intelligence unit in SARS, and SARS to produce a credible inventory of the equipment and so on. Okay, now again, that's exposition, as it were, of the recommendations on the IGI report. I mean, it says explicitly, the IGI report recommends that. Yeah. Could you say that if your intention was to conceal the fact that you had seen it?
It was not, I mean, it was not my intention. In fact, I don't understand where does this come from that I said I haven't seen the report when the judges and everyone had at the beginning where I said the report was dropped at PPSA by somebody. Secondly, the issue of me writing those letters, which we've mentioned up there, and the letters are so detailed because we availed them through Rule 53 and even everyone, and even in the Section 7.9, that here is the issue, there is this report, I have it, and can I get the correct document? Because Section 181, 3 of the Constitution demands that state institutions, organs of state, anyone must assist the public protector. I was requesting to get that from the custodian of the report. And I have it on good authority that the findings are as follows. It was because when I allowed that these recommendations and these findings and recommendations to be in this report, it was because it was relevant for the complaint and the violation of Section 201.
Yes.
So if you can see here, I showed what the findings of that was all about, because there is this unit which IGI was requested to investigate whether its operations is legal, which is the mandate of the public protector. And that's where I then said, okay, going through this report, I could find that what is relevant for me, instead of being irresponsible and say it should be only focusing on or putting all the information here and exposing those intelligence information or sources. So here I was trying to make sure that I act responsibly. And this is exactly what is in that report and the recommendations. So this shows that I've seen the report and the good authority. In my opening statement with the IGI Inspector General, will listen to that, or even to the record transcript. I told him the report was dropped. Strangely, I've even seen it in Newsweek. And the same document. Was there such an investigation? yes, there was my predecessor, the late Faith Radebe. This is what is happening. So yes, but we'll still go through that
Yes.
recording.
I think maybe, yes, we will. And that's what I was avoiding to do now, to do the blow by blow right now. We can do it in another session, but in a nutshell, I'll just ask you a few questions. In your interactions with, whether it was the minister, the IGI, advocate governor, and all that, did anybody ever say, no, there's no such report? We don't know what you're talking about.
Definitely not.
And did they go as far as to even confirm the date on which the report was finalized?
Correct. And even in those letters, when they
Yes.
were responding.
And those dates on that information, did it coincide with the report that you had?
Correct.
So, short of giving you the report, these high-ranking, the inspector for intelligence in South Africa, the minister, the legal advisors, and so on. The question I really want to know is if any one of them ever gave you the impression that the report that you had, or even the one that Nosewick had for that matter, was not the report.
Not at all.
And would you regard the minister and the IGI and advocate governor, collectively speaking, as good authorities on that issue?
Correct.
All right. Now, okay, then we deal with the KPMG report, and Mr. Moyane appointed KPMG report in 2014.
Mm,
Okay, so this is
correct.
now a second report, which we will deal with when we do the reports. But I think Mr. Pilay's evidence was that he is the one who commissioned the Skakane report.
That's correct.
And his successor, Mr. Moyane, then, according to this, commissioned the next report, which was the KPMG report.
That's correct.
And in a nutshell, we won't go into it as well now. What did the KPMG report find regarding the lawfulness of the establishment of the unit?
The covert unit, intelligence unit existed, which is 5.2, 35.1, page 50, and varied in its form and shape. Evidence indicated that the NRG only started existing in 2007, even though reference is made to a covert unit being operational as far back as 1998.
Okay, can you jump to 5.2.35.7 and 8?
Maybe 2 is very critical because that's what now this unit, sorry, Chairperson.
Yes.
You see, it was labeled various names, Special Operations, SPU, NRG, HRIU, and there's a part where we also then deal with, I think it's 7 or 8 names which were used to label this unit. So the members of the unit were not employed by SARS as they were recruited outside of the SARS acknowledged systems and processes. So the members were not the SARS employees, but they were recruited from outside of SARS.
5.2.35.7, if you can read that out.
So there was clear evidence that the intelligence unit intercepted private individual communication, which was corroborated by Mr. Van Lochenbeck's laptop, which was found with unexplained emails appearing on his allocated laptop. So that's what the KPMG finding was. So we just captured as is per their findings.
Right. Okay. So this is the second one. Again, we've glossed over the 3 reports now. The Skakane finds that it was unlawfully established. IGI says that there should actually be criminal charges against Mr. Gordhan, Pillay, and Van Lochenberg and Richa. And KPMG says that there's clear evidence of interception of private individuals. Okay.
Okay.
Yeah, then, and then they also talk about the recruitment. You've read 5.2.35.8. I think you've read that.
Yes, I've
Yeah.
read that.
Yeah.
Yes.
Okay. So, which they say was outside the system processes, yeah. Okay, then, again, another accusation is therefore, is that you ignored, quote unquote, the responses of Mr. Gordhan and Mr. Pillay and Mr. Mkhwebane, basically, and just forged ahead with your predetermined outcome without taking into account their responses. Now, taking into account the sections that follow, what do you have to say about that?
The affidavit of Mr. Gordhan, he was approached, and I think we're still going to deal with the challenges one faced with this investigation, the recording of meetings with Mr. Gordhan, the subpoena and everything, but he responded because we've captured and incorporated his response in the report. So here we were requesting him to clarify the establishment of this unit, and he acknowledged that this unit had different names. He says the unit didn't have a name originally, 5.2.36.1, as the Special Projects Unit at first, later National Research Group, and the High Risk Investigation Unit respectively. The manager of the unit reported to Mr. Pillay in his capacity as General Manager, Enforcement and Risk. Mr. Pillay in turn reported to Mr. Gordhan as the Commissioner of SARS, the Accounting Officer. So it's going back to why the Section 79 was served to the two of them, including Mr. Mkhwebane. So because of their role and their level in the system. So, and he said the unit was lawfully established to perform very important functions for and on behalf of SARS. As far as he's aware, the unit operated and performed its functions within the law.
All right.
And then Mr. Pillay as well was given an opportunity. This is part of OD. This is what we told him about the investigation, about the report. And he said he denied the allegations. He then says, he argued that the Skakane report was full, vitally flawed in fact and law, which is 5.2.38. And then he says he denied that the establishment of the intelligence unit by SARS failed to respect the constitutional status, power and functions of the National Intelligence Act. Then he maintained that the relationship between SARS and NIA was generally sound and managed in accordance with the Constitution, mutual interest and joint subject matters. And then he listed the relationship which existed between SARS and NIA. And I mean, we are capturing all that and we are showing that we did indeed take into consideration the response of Mr. Gordhan, Mr. Pillay, and then the affidavit of Mr. George Mkhwebane. We also had a meeting with him. We asked him, we said he must also tell us about this unit. And
Sorry, I'm sorry, PP. Just going to the previous one, Mr. Pillay's responses. Where he refers to, he says there were various joint investigations between SARS and NIA. There were various joint training and all sorts of things. Does that suggest that the unit had nothing to do with intelligence, or or what does it suggest?
I think here he was just trying to show that NIA and SARS or state security has a relationship with the state security agency. And I mean, if you have joint investigations between the two, which is good, because this is actually what is expected from them instead of usurping the powers of state security. And it means the officials who are doing all this work needed to be trained in this kind of work.
Yes.
Various investigations and audits conducted by SARS at the request of NIA, I mean, which is also in the spirit of cooperative governance, section 41 of the Constitution. Various investigations conducted by NIA at the request of SARS, various training courses presented between the two, a memorandum of understanding between SARS and NIA dated 2002. So this is what they were supposed to be doing. Remember, we are acknowledging you're doing good, but the fact of the matter is, then there is this unit which usurped the powers. I think that's what they didn't understand. I don't know whether it's as simple as that. We're saying it's fine, respect that NIA or state security is the only agency per section 209. So indeed, if you've got training, you've got collaborations, it means that you were trained, but then I think the training also should only focus on when you do your own, within your own mandate, this is what you need to do. And joint operations are good and joint investigations are good because that's what they were supposed to do instead of taking the responsibility.
Okay. Okay, I've been asked to check. I had someone to remind to
Yes,
check.
please,
How are
Chairperson.
you? How are you feeling?
Wait, we have a drill from yesterday, so she will indicate. We have agreed to that, so I'm wide awake when
Okay.
you did that.
Maybe I-
Bambulo.
I've got my own.
Yeah, no,
My own
that's offline.
people.
Yeah, that's offline
All right.
arrangement.
another 10 minutes, Chair. Then I can stand for 5 minutes and then, yeah.
Thank you.
I
Let's
Can go
proceed.
on for another 10 minutes.
Yes.
Okay, thank you. All right. Thank you. Thank you, Chair. All right. Now, all right. Can we, again, just to save time, I think the same general answer applies to Mr. Mahashul. He also responded. You dealt with his response. I don't think we need to go through it.
Yes, because he
in
was
detail.
also the accounting officer.
Yeah.
And by then he was in HR, corporate services. So we wanted to know,
Okay.
do you know about this? Especially the issue of recruitment, the
yeah.
establishment, he was key
Mm.
in this particular process. So we also incorporated his response. We'd never ignored his response.
Yes.
We incorporated.
Okay.
But here, Chairperson, I think the key issue is the issue of Audi, the issue of giving them a hearing and incorporating their information.
Right. Thank you. Now, then comes what I think is the core of your first step process from 5.2.44, where you deal with the application of the relevant legal prescripts. And again, we won't go deep into them for now. They're there. Members can read for themselves. But high level, it was the Constitution, which we've already dealt with. And there you specifically refer to 41, which is the cooperative governance section. 209, the one that we read earlier. 195, which is the ethical standards of organs of state. And the section 199, which talks about the integrated defense systems and intelligence and police services and so on. And then you go to legislation. And the legislation which was relevant, in your view at least, was National Strategic Intelligence Act that's 5.2.48. And then you outline what that act provides. The Tax Administration Act 28 of 2011. Yes, PP, you wanted to come in there?
5.2.40, yes.
On 40.
Okay, yes, yeah. Because I wanted to just indicate that on the issue of, again, for members, they will read for themselves, but it's very clear why.
So,
Where are you?
she's
In the legal framework,
yes,
legal framework, yes.
legal framework, yeah.
It's from 44, Tsepo, sorry.
But yes, I had just summarized the constitutional provisions.
Yes.
Yeah.
And then we went to the,
Legislation.
okay,
Which starts at 5.2.48.
oh, yes.
And I mentioned the NSI Act, which you dealt with, and you quoted. We don't need to go deep into it now. And then the Tax Administration Act.
This is very critical as
the
well.
Tax
because-
Administration Act. Okay.
Yes, it's very
All
critical.
right. Want to highlight something there?
Yes, section 41,
Mhm.
it says senior SARS may grant a SARS official written authorization to conduct a field audit or criminal investigation.
Hmm.
Then when they exercise their responsibilities under the Tax Act in person, the official must produce authorization. If the official does not produce authorization, a member of the public is entitled to assume that the official is not a SARS official as authorized. So this indicates that when they conduct their investigation, this is what they need to do. So, and then in terms of section 44 of that act, page 57, during a criminal investigation, SARS must apply the information gathering powers in terms of the chapter which due recognition of the taxpayers' constitutional rights as a suspect in a criminal investigation. So again, whatever they are doing, they should comply to the law. This shows that that's what they need to do. In terms of section 46, again, whether identified by name, require the taxpayer or another person to, within a reasonable period, submit relevant material. So that is what SARS is expected to do. So paragraph 5.2.55 is very critical. We say, however, when one considers the evidence at my disposal, which points towards specific steps taken by SARS to recruit personnel and procure surveillance equipment for the said unit for covert tapping of people's telephones and conducting illegal surveillance on people, it confirms that SARS violation of the legal prescripts which dictate when such covert activities may be permissible. So they can do those, but then they should be doing those within the legal prescripts. Now, coming to the conclusion, that's where we are applying the law to the facts. So we are saying SARS is not mentioned in terms of the relevant legislation as the one, as one of the national intelligence structures established in terms of the NSI Act. And it can only work with other law enforcement agencies within the principles of cooperative governance. So you see, Chairperson, where I was mentioning that Mr. Pillay mentioned that they cooperated. So that's where they can cooperate with other law enforcement agencies.
All right.
Yes.
Okay, well, firstly, quite apart from the content of what you've testified about now, what does all this say about the criticism that you ignored the inputs of the implicated persons?
I mean, that's why I'm saying it's so unfortunate, and a reasonable judge and a reasonable person who's reading this report would see that we have incorporated the evidence or the information we received from Mr. Pillay, Mr. Godan, Mr. Mahashula, so that we can, because there were questions we asked them, we requested information. At first here, we asked them to provide us with their affidavits in the document collection process. Remember, when we receive a complaint, we will then, after meeting the complainant, logging issues, then we will write to the individual and say, give us an affidavit. These are the allegations against you. So this is what was done in this particular process. And they responded. So this is the first audit. Then we will still come to the second audit of giving them the Section 7(9) notice to say, this is the information you provided. This is the evidence we're having. You are implicated in this matter. We're giving you an opportunity then to give us the second bite now to these issues.
Yeah.
Yeah.
Okay.
So it's here in the report.
Yeah, I know. Well, I know the chairperson said I must not dish out compliments liberally. Yeah. But speaking for myself and having read all these things so many times, I say that this is one of the best reports I've ever read from public protector. But be that as it may,
Yes.
I'm not a member of parliament. But and you're saying you had said that regarding that remark, whether it's correct or not, that Mr. Matabuche, who was the chief investigator, was one of your best craftspeople. Would you say the quality of this report was related to that fact?
Mr. Matabucha, yes, he prepared the Busasa report. This one was prepared by Bianca under the guidance of Mr. Matabucha, which
Yes.
is also well drafted. She's also one of the best
Yes.
drafters. And I
Well, I
used
know
to comment.
she's one of the best witnesses, but I didn't know she's also one of the best drafters.
No, she's the
Okay.
best. And I mean, at this level, she was at level as an investigator, not even a senior investigator.
Mm.
So, and it was one person who will also do with her experience, but also at her level, a number of investigators, they would do your service delivery related matters, but she was one of those who were falling under good governance and integrity, who were investigating complex matters.
Yeah.
So I think she was also one of the best. A number of them are the best investigators, I must indicate.
Yes.
I'm sure that time will come when you need to give awards. We're not there yet.
It's not, I'm telling you, the thank you,
Please
Chairperson, yeah.
proceed, Advocate.
You'll tell us when it's time for the Oscars. Yeah. And the drafter of the year. And well, I think when you go back when you go back
5 minutes stretch walk.
yeah, I was going to say, when you go back to
The 5
office,
minutes.
then you must do the awards.
Recording stopped.
Thank you, Chairperson.
welcome back.
Recording
you.
in progress.
UPP, over to you, Adv Mkhwebane.
Thank you.
Thank you, Chair. No, PP, I was saying, I hope you took the hint from the chair that when you go back, you must organize the Public Protector Awards,
Definitely.
and we know who the keynote speaker will be.
None other than the chairperson. Yes.
Thank you. All right, now, just to round off that second issue then of the establishment of the unit, having dealt with the prescripts, the history, the other reports, the affidavits of Mr. Pillay, Mr. Kodan, Mr. Mkhwebane, and all that. You then come to your conclusions, which we find at from 5.2.56, and I would just like you to then just maybe without even reference directly or reading directly from your conclusions, to just tell us why you say that then that allocation was sustained, as it were.
Yes, again, our conclusion, taking into consideration the complaint, the responses we've received from SARS, Mr. Kodan, Mr. Pillay, Mr. Mkhwebane, then we then came to the conclusion that the national intelligence structure, which is established in terms of NSI Act, and can only work with the law enforcement agencies. So it means that unit, good, it was there. And indeed, they should investigate. We want them to deal with the tax evaders, unlawful illicit economic trade, which is affecting our country. But it should then operate within the law. And then we also say in 5.2.57, page 58, that SARS, under the guidance of Mr. Pillay, as general manager.
Did you get that? I don't see it.
Yes.
Just repeat that, PP.
5.2.57 of the report, page 58.
Thank you.
Yes, they established this unit, which was without the involvement of NIA then. And 58 also, it shows that in the memorandum which Minister Kodan, as the commissioner, when he was writing to the minister, he said SARS had already begun operating a unit that gathered information covertly. However, as the accounting officer, Mr. Kodan should have been aware, and I believe was aware, that the unit had already started operating. Mr. Pillay reported directly to Mr. Kodan as commissioner of SARS, because how that memorandum was crafted, it was showing that this unit had already started operating. So as the accounting officer, he should have been aware of that. So the establishment of the unit with the approval of Mr. Kodan as the then accounting officer was in breach of section 209 of the Constitution, in terms of which only the president may establish such a covert information gathering unit. I think we've read section 209 earlier.
Yes.
So then Mr. Mkhwebane misrepresented himself under oath because he denied the existence of the intelligence unit. Even if the unit was never called a rogue unit at SARS, the operations and functions of CBCU, a unit that he was fully aware of existed, were similar. Hence, I said this unit was changing names over and over and over. And he just said he denied the knowledge of any unit which is doing this kind of work. I mean, being the general manager responsible for recruitment or corporate services. Surely he should have been aware. Everything should be approved through him. That's what we call, as an organization, complying to the law, your policies. And I think if they are audited, the Auditor General, if they audit something like this, they will also come up with these findings and then advise them accordingly. So further, due to the sustained denial of the unit's existence, as well as the failure by Minister of State Security to provide my office with a copy of the declassified report on the investigation conducted by the then Inspector General of Intelligence, Advocate Faith Khatebe, on the affairs of the unit, I have requested the President's intervention in the matter. So also up there, we've mentioned the letter to the President, because in my effort trying to make sure that as public protector, I'm assisted, I have this evidence, and I use this evidence accordingly.
Your mic.
Yes, thank you, Chair. No, fine. I think let's rather finish this. I just wanted to interpose something else which might have relevance to CX and other issues, but let me rather do it once because we're at the end of this section, or the second pillar of the six pillars of Part A. All right, maybe let's round that off. So those were your conclusions in a nutshell, PP, and on the basis of that, therefore, you came to the conclusion that the allegation was sustained.
Yes, it was sustained, because if you check 5.2.62 as well.
6.2, yes.
The evidence obtained during the investigation indicates that state security report found, amongst other things, because we are mentioning that report again, amongst other things, that SARS created a covert unit utilizing covert and intrusive methods in contravention of the SARS mandate.
Yes.
So this is also showing that I wouldn't say something like this if I don't have the copy of the report.
Yes.
And SARS had an interception and monitoring of communications capability, which went beyond targeting tax offenders, but also utilized for political purposes, as per the documentary evidence in my possession. So this also, it's not just the thumbs up. Political purposes, I have indicated that there were documents and videos which showed, besides the interviews or the recordings of the meeting of Mr. Those recording of Helhart, which we're going to play. Deval and the
Lombard.
Yes. So where they were confirming that indeed this is what they did, they installed those cameras at DSO. Yes, the intention was something different, but unfortunately it ended up having to go beyond the mandate of SARS, because it was not relevant or related to SARS.
To tax, okay. Yes, now we'll deal with that when we deal with the operations leg.
Yes.
Okay, no, thank you, PP. Now, I just want to say, Chair, in rounding off this section, just to pose this question. You've taken us really through the journey of how you then got into your conclusions on this issue of the lawfulness and or otherwise of the establishment of the unit. Again, when we get to the judgment, you'll find that one of the, well, probably the most prominent criticisms is that you effectively embraced, let me put it that way, discredited, quote unquote, reports on these questions and put aside whether they were indeed discredited or not. But in your conclusions here, is there anywhere where you regurgitate or rely or adopt anybody else's findings, or were these findings from your own investigation?
I would want to say that mentioning these reports, we were showing that there's this investigation which was done by Skakane, done by KPMG. There was a legal opinion which was requested, and showing all the people who have investigated the matter. But then you will see that our focus was whether there was any violation of the legal prescripts. So if that can just be understood, that was the only focus. Yes, we checked the information, we couldn't ignore it. And remember, in our investigations as the ombudsman or public protector, we use such information as leads, meaning, for instance, on own initiative investigation, we can hear the Mkhulu, for instance, Hall issue, which was an own initiative investigation. Instead of taking it as is, or the Gupta leaks, for instance, we'll deal with it. But you use that, it's an information. It's not the gospel truth. It's not evidence. Then after these reports, then we will go to the source of the, okay, Skakane interviewed the following. KPMG dealt with this and they are saying the following. Okay, these are the laws which they referred to. This IGI report, indeed, they're the only institution which investigates intelligence-related issues, because one misunderstanding which a lot of people I interacted with, your legal advisor, Kavenda, Minister of State Security, Ms. Duba, because that was a very close session with her. And she was also saying, no, but public protector, SARS is not an intelligence department. I'm saying that's the very purpose of the investigation conducted by Skakane, referred that part to you as IGI, and IGI is overseeing state security. So the main aim was just to check whether they operated within the law, nothing more, nothing less. And in the report, there's several instances where I'm saying independently acquired evidence. So we use this as leads, and then we approach SARS. SARS, can you provide us with this? Okay, we also conduct our own independently acquired means of acquiring information. So this is why we came to the conclusion based on our own investigation, not just regurgitating or just taking whatever they are saying, but because of their findings and their conclusions, we are seeing that, but the information which we have, in fact, not information, evidence which we have, and what the law is saying, indeed, there is a violation of this law.
Yes, thank you very much. Okay, we'll deal then with the third leg, and I think it will be quicker, Chair, because as I said, this probably of all the things you are investigating is the simplest, which is, as I say, this straightforward PFMA.
Exactly.
Whether something was procured properly or not. Anyone would know that in the public sector, really, you can literally pick out anything, whether it's a car or a computer, and the people who work there must be able to say, where did it come from? When did it come? And so on and so on. So the Chair, if I'd request that we break at this point so that if I start with the next leg. But I just, if you agree, I wanted just to deal with that issue that I had flagged, which I said it doesn't really fit in.
Maybe you can just assist me as a chair of the committee, just as we conclude this in a minute or two,
Yes.
to indicate in summary, what evidence are you placing on this establishment?
On the establishment. Sorry, I don't understand the question, Chair.
Having gone through
Yes.
this,
The history.
yes,
Mm.
and in detail,
Yeah.
I'm asking you the PP to just summarize. in
Okay,
2 minutes.
perfect. Yes, thank you. Yes, I understand now. Yes, I think the church just wants to know, we now know that you've gone through all the elements of whatever you went through, and you therefore say that that allegation that the establishment was unlawful was established. So the chair now wants you to summarize as to how you reached that conclusion on the number 2 pillar.
Okay, I think we dealt with the conclusions, page 58,
Mhm.
because that's where I'm saying, Chairperson, the fact that the unit was established and we've shown that what section 209 of the Constitution is very clear that it's only the state security, defense intelligence, and SABC intelligence. SARS approached Minister of Finance to approve the establishment, but they've already started doing that. And I'm saying, Chairperson, not stopping SARS to do its work. And I think we've shown you the observations which we had to deal with, that they needed to cooperate with state security agents. And hence Mr. Pilay's response and Mr. Gordon's response is also incorporated here, where they are indicating what is their view. So we've given them the OD in this particular issue, which is not true that we didn't allow them to respond. And secondly, the intention again for the committee, Chairperson, is that this investigation was conducted with an open mind as far as this issue is concerned. And we are showing that what the interception of evidence or interception of information, what it says about the operations of this particular unit. Also, I'm showing here the establishment part, that there was also a report by IGI, which we're still going to deal with it in details, where I was trying to acquire it properly, and I didn't regurgitate the reports of Fabos Kakane, KPMG, Kroon, and everyone, which we're still going to deal with those. But I'm just showing that in the investigation as the public protector, we use that as information or as leads. Then we acquire our own. In other words, it helps us to know where do we start, or where the investigators are starting to investigate. So those are the traits of investigation.
Yes,
Thank you. That's helpful.
Chair, yes.
Now we can
Go
proceed.
to my,
through.
yes, no, thank you, Chair. Well,
Thank you.
and as you know, one question always leads to another. So I'm just going to piggyback on the chairperson's question and maybe zoom it more.
I thought you'd done with the.
No, I just want to ask one specific question, Chair. So your question has helped me to do that, just so that we don't go back to the so-called establishment issue.
Yeah.
I'd like you literally to just focus. We've heard everything you've said, Kakane and this and so on. But it would seem that if you like, the nucleus or the smoking gun in this whole thing is the memorandum to Mr. Manuel. Can you maybe in answering the chairperson's question in a more focused way, just zoom into the importance of that, given its content, its author, its destination, the comments around it, and so on. What to you as the public protector, what role did that play in just this establishment issue specifically? Thank you.
Thank you so much. I think that helps chairperson also. It's just that I don't know why we didn't show it, and just to see that the preparer of the memorandum, and that is a reliable source document. Besides relying on Abu Skakane and everyone, this one comes directly from SARS as the
Remember when,
institution which we were investigating.
when Ms. Mkhwebane was here, we did go through it.
Okay.
So
Sorry, and that was the reason. We remember we said as far as we can, just for the sake of progress, we'll use the source document as the report. But maybe tomorrow morning before we start, we can display it. But
Problem.
yeah, but for now, just because of the time, if you can answer the question.
It's very critical.
Yes.
Yes, it's very critical because the accounting officer signed on this.
Mhm.
The accounting officer acknowledged that already the unit is operating, and acknowledged that the unit is operating, and we would want to have an MOU with the NIA because what the unit is doing falls within the mandate of NIA or state security.
Mhm.
So this memorandum was acknowledging or agreeing that we know that this is not falling within our mandate, but we need state security agency to collaborate with us. So hence the comment by Deputy Minister Muleketi,
Mhm.
when he was noting the matter, actually is not approving, but just noting, but being concerned that you cannot, or this shows or reflects that it's a mandate of state security and you want to supplement, because the memorandum of understanding say they want to supplement. So it means the operations were there. And, but the key issue is, this is the document which we relied on, which is, it belongs to SARS.
Yes. Sorry, Chair, well, PP, we wanted to relieve you, but you've invited the next few minutes yourself. Can we then go to bundle A, page 7842, just so that we don't have to display it tomorrow?
okay,
Just,
what are you looking for?
is that letter?
That letter.
Yes, just so that tomorrow we don't have to go
Yeah.
there. Yeah.
I see your sheet there. Make sure that
Oh.
we're never going to forget it. You know. So now the she has
The
reviewed
she-
herself.
absolutely doesn't want us to go home. Thank you.
Okay.
So 7842, bundle A. Yes, no, the public protector is quite right. This is a crucial piece of, right. Okay, let's go through it slowly, well, not slowly, but carefully. You can see the letter, it's got all various stamps, 12. It's got various stamps, all dated 12 February 2007.
Correct.
And it's on the SARS letterhead, right? And dear Minister, and then it is, okay.
So
Then
the
can you go
purpose-
through it? I
yes.
think the critical paragraph is 2.1 and 2.2, but just give us the context.
So the proposal or the purpose was to request approval to fund a special capability within NIA. So they wanted to fund it within NIA, acknowledging that this is not their mandate.
Mhm.
But then they fund it within NIA to supply SARS and the law enforcement with the necessary information to address the issues of illicit economy. So the discussion then is what they were saying, the collecting of technical intelligence, and the interception of the organized syndicates, which the country should be doing. So this is
Chair,
also
PP, no, please read the thing
okay.
word for word.
Collecting
You're the one who said
technical-
we must bring
Okay,
it.
Advocate Mkhwebane, he is not the chair yet. So
Yes.
you, because I think you're mindful of your time, but I don't mind if you can do what is, but he's not the chair. Yeah.
Thank you. I've been put in my place.
Proceed, Advocate Mkhwebane.
Yes. Collecting technical intelligence invariably means oh, I'm struggling to read.
It's quite faint.
Mm,
It's been copied all the time. So
yes.
so it's been part of the Rule 53 many times, I'm sure.
Yeah, I think that's why. So it deals with the
But you can summarize it, PP, I think the way you were doing.
intercepting organized criminal syndicates.
If I may assist,
Mm.
if you go to page 42, that's where the
Is
same
it
like
clearer?
the same-
Clearer there?
it's clearer, yes, it's 42 of the report, yeah,
Okay.
where we were reading. At least, okay, sorry. No, yeah, 42. No, I thought we were going to finish with that one and then come and read it from here, yeah. But it's
Mm,
fine. I think everyone knows that it was to Minister.
oh,
Manuel.
yes, yes.
Okay,
So page 42, page 5.2.7.
yes,
The memorandum requested approval to fund a special capability within NIA to supply SARS and law enforcement with the necessary information to address the illicit economy. The memorandum further stated the following: 2.1, collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity. So I said it earlier that this encourages, or this acknowledging that they don't have the mandate.
right.
Discussions are taking place with the national intelligence to supplement SARS intelligence capability. NIA is willing to create a ring-fence capability, provided funds are made available to cover personnel costs. All other costs will be covered by NIA. NIA is willing to formalize the above mentioned arrangement into an MOU. 2.3, we therefore request that NIA's budget be increased to fund the creating of this special capability.
Okay, Tsepo, can I go back to the actual letter now? Right, sorry. Okay, you've read, I think, what are the important parts, Chair? Can you then just go further up?
The estimated personnel costs.
Course, yeah, all right.
Yes.
So then
which is-
the estimated personnel costs,
2007-8, it's 13 million. 2008-9, it's 17 million. 2009-2010 was 18.8 million.
right?
Mm.
And maybe let's just pause there, Chair, to jump a little bit ahead on the equipment issue. Just on that budget, when we deal with the equipment issue tomorrow, one of the issues that you raise in the report is that such a unit costing as much money as this, there's no way that it didn't have any equipment. And if it did, then you would have wanted to know how it was procured. I just wanted to flag that just so that these amounts can be kept at the back of
At the back of my mind, yes.
All right, next one, 2.5. Right. Oh, sorry. Yeah. Then just comment on those, what we see there.
So this document again, Chairperson, I said, these are the kind of documents which I will encourage officials to rely on instead of media articles or just some reports, but those reports are leads. So here it shows that this was prepared by the General Manager, Enforcement and Risk. We know that it was Mr. Pillay, and then the commissioner then was Mr. Kodan, the Commissioner of SARS as the accounting officer. Then the deputy minister, then it was saying approved or not approved. So his comments were, as we've captured here, asking this is the responsibility of NIA. And I see that you'd want maybe to supplement that function or the existing units function within SARS. Then the Minister Manuel then just approved this submission. So communications in government, that's how it is, because once it's signed by the minister, when you request that approval, it means it was approved.
Yes. Okay. So as far as approval is concerned, this was clearly directed to the minister,
establishment.
prepared by the relevant official, Mr. Pillay, signed by the accounting officer, Mr. Kodan, countersigned by the deputy minister, and signed, and therefore it was, as you say, a proper legal document or memorandum. Okay, thank you, Chair. I think I hope that covers your question, Chair. Yes.
Yes, thank you.
Just then my issue again, just so that we don't spill it to tomorrow.
Sure.
I want, this is, shall we call it homework, not just for tomorrow, but something that I just wanted to highlight, which postulates, particularly into SARS, regarding the role of the public protector. SARS, CX, when I say SARS. The role of the public protector, remember there's this debate about whether your mandate includes saying anything about the Constitution and so on.
Yes.
Yes. If you go to section 181, Chair, 181 of the Constitution, that, as we know, is the governing provision, not just for the public protector, but for all Chapter 9 institutions.
81.1.
Yes.
Okay.
181.1, yes. Now, this talks about state institutions supporting constitutional democracy. And it says, yeah, the following state institutions strengthen constitutional democracy in the Republic. And the first one is the public protector. Now, again, addressing the chairperson, the committee, and the public, what do you understand about that concept? That the role of these Chapter 9 institutions, after all, is to strengthen a constitutional democracy. Does that mean that there are areas within the Constitution or the constitutional framework, including the Constitution itself, where you are not allowed to go?
Definitely, it's very clear for all the Chapter 9 institutions. We should be assisting actually the country to implement or to make sure that the Constitution is a living document and is applicable to all citizens. Therefore, this Chapter 9 and Section 181 is very clear that we are there to support constitutional democracy. And how we do that, there should be transparency, there should be cooperation, they should even assist us in the performance of our responsibilities. So I think that was interpreted in the Nkandla judgment, where we can access any information. You know, you go deep into raw state power, whatever information you require. Hence, in the number of engagements with in this investigation, I was very clear that you cannot indicate that you can't give me the IGI report because this is necessary for the performance of my responsibilities. So it's like then stifling or not cooperating with us. I think SARS, it's a number of issues which we had challenges with.
Yes,
So Advocate Mkhwebane, so it is also fitting that the National Assembly develop rules for all of these institutions.
That's correct, Chairperson, not only for the public protector, all these institutions, yes.
Okay, thank you.
yes, and for the sake of completion, let's then link that to 181.3.
Correct.
Can you comment on that one?
So this one is at the core of what is expected from other organs of state.
Including the National Assembly.
Yes.
Yes,
Through legislative and other measures must assist and protect these institutions to ensure that the independence, impartiality, dignity, and effectiveness of these institutions is guaranteed. So I think we will deal with that, possibly we'll deal with that when we also deal with the evidence of Public Protector Sakoni, because it was like, okay, as the National Assembly, you've established this committee. And I think in my statement also, we indicated that what are the expectations from me and how did they assist me in ensuring that they assist me in getting any information in the ensuring that I'm independent, I'm impartial, the dignity of this institution and effectiveness of this institution, especially the dignity. I think I've mentioned several times, or there was an instance where I mentioned that there was a stage where I also mentioned with portfolio committee that, you know, I feel like being attacked in all angles. And the very same mother as well, being the speaker, also joining in, or the parent joining in to victimize or to deal with me, instead of the National Assembly protecting me as the incumbent in this institution. So this is very critical, especially section 181.3 for any other chapter 9 institution when we are performing our work under this. And as well, it was even worse when I had to be clobbered with personal costs in my private capacity. And a lot of those, what does it say to this? And how do you assist and ensure that I maintain my independence, impartiality, dignity, and effectiveness, which is very critical, because the minute you disarm or you cause this institution to operate with fear, or all these institutions to operate with fear, then it means the citizens are on their own. They are not protected.
Thank you, Chairperson. In my language, they say drops mic. I think that's where we should stop it for today. Thanks.
Thank you. I missed that. Maybe it's better if I
No,
missed it.
you won't understand, Chase, for the youngsters like
Okay,
us.
okay. Thank you. Thank you. Thank you. The time now is just about 18 minutes plus 5. We are going to adjourn for the day. Pause there and start tomorrow again at 10 to proceed with the remaining 4 areas under that. And I'm asking that members, so that we don't repeat today's late start. We'll start at 10 tomorrow. Thank you very much.
Thank you,
The meeting is adjourned. Thank you.
Recording stop.